Hello and welcome to Generation Rent's first webinar of our Renters' Rights Awareness Week on Monday the 13th of October. My name is Wilson Craw. I'm Deputy Chief Executive at Generation Rent. And this is the session we've got on repairs and what to do if your landlord is not fixing something in your home. I'm joined by Eleanor Solomon, who is a partner at Anthony Gold Solicitors and also a board member of Generation Rent. She'll take us through what rights you have as a renter in regard to problems with your home, what your landlord's responsible for, and what to do if they're not doing their job. I'll follow up with some reflections from Generation Rent around what we hear from tenants and from councils about how tenants can improve their homes, and then there'll be some time for questions from the audience. So if you have a question that you'd like to ask myself or Eleanor, please put it in the Q&A. Just note that we aren't able to provide personal advice. All we can do is offer general principles and some insights from our work that may be helpful in dealing with any problems that you might have. As I say, we're broadcasting right now on YouTube. So if you'd like to remain anonymous and are in the Q&A, you can do that. I'll just check if there's anything else I need to mention before we get started. But I don't think there is, so I'll hand over to Eleanor. Thank you very much.
That's great. Thanks very much. Right, I will just share my screen. Hopefully that's okay, and you can now see my presentation. Is that right, Dan?
Not
no?
quite. I think it normally takes a little while.
Okay. How's that?
Yeah, it's starting to load now.
Okay.
There we go. I can see it now.
Okay, so I'm going to talk through the kind of the rights that you have now before we have the Renters' Rights Act, which will hopefully be coming into force relatively soon. So there's lots of different bits of legislation that gives you rights. I mean, don't worry too much about them, but this is just to show you that it's not always straightforward. One straightforward place to look is the tenancy agreement, which should set out quite specifically what rights you have. But if something isn't written in the tenancy agreement, don't worry, because you have other rights anyway, regardless of what your tenancy agreement says, or even if you don't actually have a written tenancy agreement, as long as you have a tenancy, you do have rights for your landlord to make repairs in your home. So we'll go through where those are. So start by looking at the written agreement, and it might say, for example, the landlord must repair all the utilities and white goods, for example. Now, they don't necessarily have an obligation from any other bit of legislation to repair, say, a fridge or a washing machine, but if it says in the tenancy agreement that they do, then they do, and you can rely on that. So the tenancy agreement will always give you more than you might get from other bits of legislation and from your basic rights, but it can't take anything away. So if your tenancy agreement says the landlord doesn't have to repair anything, don't worry about that, because that would just be invalid. Then we go to Section 11 of the Landlord and Tenant Act 1985. So that applies to any tenancy of less than 7 years, so not to a long lease, basically. And the landlord can't contract out of it. So as I said, if they say in their tenancy agreement it doesn't apply, that's just irrelevant. They can't, that would be meaningless legally. What it says is that the landlord must repair the structure and exterior of the property. So that's the roof, the walls, the windows, the gutters, anything on the outside, or anything forming the actual structure of the property, including wall plaster. And they must keep all the installations for water, gas, electricity, sanitation, space heating, and heating water in repair and proper working order. So these are the things that the landlord absolutely just has to repair. Now, just because something isn't in repair doesn't mean that the landlord's in breach of the tenancy agreement and they've done something wrong legally. Obviously, things always break in any home, and the obligation on the landlord is to fix things once they know that they're broken. So it's really important that you tell your landlord if something is broken, And whilst there's no obligation legally to tell them in writing, in fact, however they come to know about it is fine. If they just walk past the property and see, if their friend tells them as they're visiting to do something else, if the gas inspector tells them, however they get to know, it doesn't matter. But just from an evidence perspective, you should tell them in writing, just so that you've got evidence at a later date, if you need it, that you've told them. And then once they know that there's a problem, they've got time in law to carry out the repair if it's inside the rented property. And how much that time is isn't specified in law so far. Our ABS law will change that a little bit, but so far what they have is a reasonable time to carry out the repair. And what is a reasonable time? It depends on what the repair is. So if there is subsidence, for example, a reasonable time might be well over a year, because they might have to monitor cracks and then do underpinning, and it may just take that long. If the repair is an escape of boiling hot water, then a reasonable time to come and make that safe at least might be a few hours. So it's just factually dependent on what the repair is. And then another piece of really key legislation is the Fitness for Human Habitation Act 2018, or the Fitness Act. And what that says is that a dwelling, so any house or flat or home, has to be fit for human habitation at the beginning of the tenancy and continue to be fit for human habitation. What does that mean? It doesn't mean that flats or houses have to be not uninhabitable, because that would be a very, very low bar, and that would almost never apply. But what it means is it's unfit for human habitation if it's so far defective in one or more of the following matters, which I'll go on to, that it's not reasonably suitable for occupation in that condition. So what that means is, if you have something in your home which is making a health and safety risk or making it unpleasant to be there, it's fairly likely that the Fitness for Human Habitation Act is triggered. And it could be that you have lots of small problems which by themselves wouldn't make a home unfit, but if you have loads of them, then altogether that would work to make a home unfit. Or it could be that you just have one big problem which absolutely makes the home unfit. So what are these problems? These problems are set out in the Act as it covers almost anything you could possibly think of that could be wrong with a house. So the main ones are here, and then it says a prescribed hazard, and what a prescribed hazard means is the hazards in the Housing Health and Safety Rating System hazard. So these are the same things that your local authority would look at if you went to the local authority and complained that there was some kind of repair problem in your rented home. And you can use these same items or same kind of problems to sue your landlord privately and say that there's a hazard in the home. So they are, I mean, as I say, the first lot of them are here. There's 29 of them. They really cover almost anything that you could possibly think of. Damp and mold growth is by far the most common ones, but you might have lead or radiation, or domestic hygienes, pests and refuge. That might be like a mouse infestation. Entry by intruders. That might be that your lock to your front door doesn't work, so somebody could break in quite easily. Excess heat is really, really common in new build flats recently, or excess cold. Might be that the heating doesn't work, might be that the heating does work, but it's just really cold anyway because it's drafty. And the third lot of them, there's lots of ones to do with falls as well, which environmental health officers from the council are always very keen on. So those could be things like stairs that don't have the right banisters, or I don't know, paving slabs that aren't even, levels that have just sort of drops in them, lots of things you might not even pick up on necessarily. Obviously fire is a huge risk that could make a home unsafe, that everybody's been rightly very, very aware of recently. So that is the risk of fire, not there actually being a fire. So if your home suffers from any of these hazards so much that it makes it unsafe or really uncomfortable, then there's a good chance that your home might be unfit for human habitation. There are exceptions. So if you've caused the problem yourself, basically, which is what failure to use it in a tenant-like manner says, or you've breached your obligations. So say you've broken a window, it's not going to be a breach of your landlord's obligations that there's a broken window. Or if it's a work that the tenant is supposed to do, like just a really minor job, like changing a light bulb or bleeding a radiator, the landlord's not obliged to completely rebuild anything, which is been destroyed in a fire. But apart from that, you might have an obligation under the Fitness for Human Habitation Act. And that does extend to the communal areas as well. And if your landlord doesn't own the communal areas, that's quite limited. You might be better off complaining to whoever does own the communal areas, like the freeholder. So what I've just been speaking about is your power to sue your landlord in the county courts. And you can get a solicitor to help you do that. You can write a letter yourself and threaten, to sue them and see how far you can get in getting them to do the repairs, or, negotiating some damages. But ultimately, it can be quite difficult. You can't always get a solicitor, especially if your case is against a private landlord who may not have very much money and or the repairs issues may not have been going on very long. So probably the best first step as a private tenant is to go to the local council, and the local authority have powers based on the same HHSRS hazards that I've just mentioned that you have rights in relation to as well, to privately sue your landlord. And they can serve a notice on your landlord, like an improvement notice or a prohibition notice. But even if they don't do that, what they probably will do is go around and produce some kind of written report on what they think is wrong with the property. And that can be quite good evidence that you can use yourself if you want to try and negotiate with your landlord, or try and get your landlord to pay you some compensation. So it's really well worth doing, even if the local authority end up not serving an improvement notice or a prohibition notice on your landlord. So what can you practically do? Don't withhold rent. I know it's always tempting, but all that you're going to find yourself in that situation is a situation where your possession proceedings are against you. And it's really lots of times tenants think, well, okay, great, and then I'll be in court and then I can raise all the repair issues to the judge. But really, you can raise repair issues to a judge anyway. If you start your own claim, you're just in a much worse position if you wait and don't pay your rent and then there's a threat against you. Do complain in writing and do keep records of your written complaints. Do give access to your landlord for works, otherwise they will have a defence and they're allowed to have access on 24 hours written notice. Do report the issues to the council, and not wholly relevant, but just check whether your landlord has an HMO licence and if they need one, because if they don't, then you can report that to the council as well. And you may be able to get a rent repayment order. And then consider bringing a claim or writing a letter to your landlord and threatening a claim, even if you have no intention of actually starting a claim in court. It may be enough to force your landlord to take the repairs seriously and to make them do them. That's the end of that.
Great, thanks very much, Eleanor. That was really fascinating, and really, really comprehensive, setting out what rights you have and what options you have. I've got a few slides from Generation Rent's perspective on what we have heard over the years from councils and from tenants. And I'll share that now. So just bear with me a moment. Here we go. So yeah, as Alan's just outlined, one of the things that we find is really helpful for tenants if they have a problem that their landlord's not fixing and thinking about going to the council, is checking if your home needs a license and also has one. So HMO licensing, houses in multiple occupation, is the most common type of license that it might need. So if you're living with 4 or more other people, so a house with 5 or more sharers, then and you're all unrelated, then, or at least two of you are unrelated, I think, your landlord will need to have a mandatory HMO license for that. And then some councils have brought in what are called additional licensing schemes. So those are licenses that landlords must get if their property has 3 or more sharers. And then some councils have licensing schemes where basically all private rented homes. So if you're in a single person, if you're in a couple, if you're a family, then in those areas, all private rented homes will need a license. It's normally looking on the council's website to see if your home needs a license, but there are some websites out there, not enough, to be honest. There's one called Tuxa, which is TUXA. I'm not sure. I think they're relaunching, but one of the great things about that website, if you type your address in, you can find out if your home needs a license. And then your council website will normally have a register, which will contain a list of licensed properties or an ability to search your address to find out if your property has a license. And if it's not licensed and it needs to have a license, then it's possible to get a rent payment, which means that your landlord may have to give you back up to 12 months of rent. That's actually a subject that we're going to be looking at on Friday lunchtime, in our final webinar of this Rents Rights Awareness Week. So that's one thing to look into. The other thing, what's particularly helpful about checking that is that the council will often have more stronger powers to take action against the landlord if the landlord, whether or not the landlord has a license or not, and the home has some hazards in it. The council can often act more quickly in those sorts of situations. One of the most common problems that renters have come to us with is around damp and mold. So it's one of those areas where it can be quite difficult for a tenant to persuade the landlord or even the council that the damp and mold is something that that's not their fault. A lot of landlords will tell tenants to open a window or not dry clothes inside, or basically things that are really either really obvious things that tenants will normally have tried, or things that are just completely unreasonable behavior for tenants to expect of tenants. But increasingly, there's more recognition that mold is a problem with the home, and a problem with the maintenance of the home. The landlord needs to do something about. Often a lot of damp and mold problems arise because water is getting into the home through the roof or through the walls. So one thing to check is whether your roof has any broken tiles, because that could be letting water in, or if there's damage to gutters or drain pipes, which causes them to leak when it's raining. So when it's raining, you could check if there's any spraying of gutters during a downpour. Another thing that's worth looking at is your home's energy performance certificate. So all private rented homes have to have one. If your home has an energy efficiency rating of D or E, those are actually there's expected to be more higher standards, which will mean that landlords will have to raise those properties from a D or an E to a C. But at the moment, those are legal, but they do come with higher risk of damp problems or cold hazards. And that could be something to point the council towards, you know, as evidence that it's not something that you're responsible for as a tenant. And then it's worth knowing that F and G properties, properties with an energy efficiency rating of F or G, are actually illegal to be let out at the moment. For the past few years, it's been the case. And another thing is that right now we still have Section 21 evictions. Your council can protect you from Section 21 for 6 months if your home, if they serve an improvement notice, which is something that Eleanor mentioned. If your home has a Category 1 hazard and is and you're worried about being evicted by complaining, the council can potentially protect you in those situations. So those are some things that's worth thinking about before you can contact your council. Eleanor touched on some of this as well. You would normally expect to get a report after an inspection by the council. Often, you know, it will be very important for the council to inspect the property and not, and it's one of the things that that could help you in future with any legal action you need to take. Although councils can serve improvement notices if there's a hazard, very often we find that councils will just write an email to the landlord or phone them up and say you need to make these changes, which doesn't provide the sorts of protections that that tenants need to make sure that, particularly where the landlord is kind of known to be you know, repeatedly failed to make improvements to the property. But as I mentioned, an improvement notice does give you protection from a Section 21 eviction for 6 months. And then also, if the landlord fails to comply with an improvement notice, that's another reason that you could apply for a rent repayment order and claim some rent back. The council may need to be chased if the landlord fails to carry out repairs, so that you have evidence that you need to take further action yourself to apply for a rent repayment order. And also, it can often be the case that the landlord might do a poor job and may not actually address the problem that you've gone to the council with originally. And I'll just mention, because we are expecting the Renters' Rights Bill, which will abolish Section 21 finally, after many years of campaigning by Generation Rent. We've got a very it's a very big bill with lots of things in it. Section 21's sort of the flagship kind of change that they're making. So what that will do is make sure that the landlord has a valid reason for evicting you. So at the moment, Section 21 means that you know, they don't need to prove to a court that they have a particular reason they need the property back. So a lot of landlords abuse that and use that as a way to stop tenants complaining in the first place. So without Section 21, and with what we hope will be a tough regime against landlords who do abuse the new grounds for eviction, so they will still be able to evict to sell a property or move in themselves. There will be restrictions on what a landlord can do after that. After the tenant moves out, they won't be able to relet it for a period of time. But if they do relet it, then the tenant again will be able to apply for a rent repayment order. And so we're hoping that will stop landlords from reletting the property or from abusing new eviction grounds. There's a tribunal that you can go to in certain circumstances if your landlord increases the rent. This is something to be aware of because it'll become more important once the bill has been passed. It'll be the only formal way that a landlord can increase the rent. It'll also be more worthwhile a tenant actually challenging a rent increase at the tribunal. So it's not perfect. It's not exactly what we want, but the tribunal will look at essentially what a landlord can get for the property on the open market, what rents are being charged on new tenancies, and they'll either set the rent at that level or the landlord's proposed rent if that's lower. So in many cases, tenants may find that rents have gone up a lot locally and will still be an unaffordable rent increase. Obviously, that's a bad thing. Something we're trying to push the government to go further on. But one thing to bear in mind about the tribunal is that about 2/3 of tenants actually get a discount on the rent, because the tribunal will look at the quality of the property and the condition of the property, and if it's in poorer condition than similar properties nearby, then they'll take that into account on the rent. So sometimes if your home is in poor condition, then and your landlord asks for higher rent, that's another way of exercising your rights to a better quality home, or at least getting better value for money on what you're paying. A few other things that we're expecting from the Renters' Rights Bill. I should say that tomorrow we have a full webinar on the Renters' Rights Bill as a whole. We're expecting a database to come into force with where all private rented properties need to be registered on that database. That will help. That'll do a lot to help local authorities, councils to enforce existing laws. Council officers will also have some extra powers that they can use to investigate and take action against landlords. If a landlord's not on the database, then that's something they can tackle a landlord on immediately. So we're waiting to hear when that's going to come into force. I believe they're testing a version of it right now with landlords. There will be an ombudsman as well, which will be about an ombudsman will allow tenants to complain about their landlord if the landlord ignores a complaint or fails to address a problem. A tenant can go to the ombudsman, and that'll be another way that tenants could get compensation. Again, we're still waiting for the final details of that. We won't hear about those probably until later this year or early next year, and it won't come into force for a little while yet. The Decent Home Standard already exists in the social housing sector, so that's being extended to the private rented sector, which is really good news. Although, again, the timing is to be confirmed on that. The government has talked about it not coming into force until 2035, which sounds a bit crazy when, given how bad things are in a lot of places. In a lot of homes, 1 in 5 homes is classed as non-decent. So it's going to be really important to that landlords are under pressure to improve the quality of their homes. One thing that will be good, and it could potentially come into force a bit sooner, is that councils could fine landlords for having hazards in the home without needing to go through an improvement notice process first. So that's one of the benefits of that Decent Home Standard potentially in the next few years. And then finally, I've got a typo here, but our Labs law is is one final element of the Renters' Rights Bill. Again, that is being brought in social housing sector. It is specifically focused at damp and mold problems. Because of the toddler hour, a shack who died as a result of mold in his home a few years ago. What that will do is make sure that landlords have certain timescales that they have to hit in terms of their carrying out repairs or responding to problems. So that is one more one final bit of the Renters' Rights Bill. As I say, there'll be more on that tomorrow evening. So, Eleanor, any comments on that? Otherwise, I'll head to questions.
Yeah, just on AWAB's law, I guess the interesting thing for me about AWAB's law is the right to temporary accommodation. Essentially, if the landlord can't do something to make a hazard not significant or urgent immediately, because currently there's no right to temporary accommodation. And in the private sector, it's actually relatively rare that a private landlord will provide temporary accommodation for a tenant if the property is unfit, but they will have to under AWAB's law. So that's a really good, that's a really positive change.
Right, thank you. Just a couple of questions, just practical questions. Someone has asked, can we share a copy of the presentation? We'll do that. We'll send an email around after this. Well, probably tomorrow, to be honest. So just having a look at some of the questions. We've got quite a few that have come through, which is great. Thank you very much for asking. A very short question. It's when would a repair be invalid? Do you know what that might be in reference to? Or...
I'm not sure, but I'm not sure what that means, honestly. But there's another bit below which, in context, might be make more sense.
But yes, I'll read the next bit. My landlord took 6 weeks to repair the lock on my front door, and got cross with me when I paid to have it repaired the following day when it broke 8 years later. Was I wrong?
Unfortunately, yes, because you're not allowed to repair things yourself, save for in very specific circumstances. There is a kind of self-help remedy you are allowed to use to repair small things yourself, like a lock on the front door. That's a kind of good example. What you're supposed to do is complain to the landlord first, and then if they don't respond within a reasonable time, which in the case of a lock on the front door, if anyone could break into your house, would be really quite quickly, because that is an urgent job, but you must report it first. And if they refuse to do anything or don't come around within a reasonable time, you're supposed to get 3 quotes and then do it yourself, and then you can withhold that sum of money from your rent. But I mean, with a lock on the front door, it's not a really big deal, because it's not something like messing with the boiler or something structural. You can't really do much damage. I can see why you would do that, but technically you're not supposed to do that. You're supposed to report it to your landlord, and they're supposed to do the repair.
Thanks. Is there, I mean, you mentioned changing light bulbs. Obviously, that I suppose that's a kind of typical thing that the tenants are expected to do. Is there a list of these things that are very much the tenant's responsibility?
There are actually, and some of them tenants might assume are the landlord's responsibility, and unfortunately there's not a list all in one place, but there are various cases which say, off the top of my head, things which are the tenant's responsibility are bleeding radiators, changing the washer on a tap, changing light bulbs, unblocking the sink. So as long as you don't need to use some kind of mechanical unblocking, if it's just a matter of putting some stuff down the sink to unblock it. All of those things are the tenant's responsibility, that are considered to be minor jobs.
Thanks. Got another question about I suppose it's about the different levels of categories of hazard. So got category 1, which is the most severe hazard, and category 2, which is less severe. This member of the audience says they don't have to put a stair banister in as it's only category 2 or something. is what the council said. Is there a is
So
a good rule of thumb in terms of what might be
yeah,
a category 1 or 2?
so the first thing to say is whether something is category 1 or category 2 is relevant for the things that the council can do, like serve improvement notices or prohibition notices. It's not strictly relevant for the private rights you have yourself. But on the other hand, if something is a category 1 hazard, it's quite likely that it's also unfit for human habitation. Now, all the kinds of things that could go wrong, all the kinds of hazards could be a category 1 or category 2 hazard. But it just depends, very fact specific, and it depends how bad they are. And an environmental health officer will do a calculation based on the likelihood of something bad happening and how bad that will be if it does happen. So, for example, if there's a low likelihood of a gas explosion, because a gas explosion is so serious, it doesn't have to be very likely at all that there will be a gas explosion for that to be a category 1 hazard. But if there's a low risk, a similar kind of statistical risk of somebody falling down 2 steps, then it has to be much more likely that someone will fall down 2 steps, because obviously not so much harm can come to you if you fall down 2 steps as it can if there's a gas explosion. So in the stair banister example, it will depend on the stairs. So how many stairs there are, how steep they are, all of these things. So it's a pretty opaque process, and I'd imagine that in lots of cases, if you've got 5 environmental health officers in to look at the same set of stairs, they might come with 3 different conclusions between them, because whilst it looks very scientific, it's actually not, in my opinion. Sometimes it's very obvious because something's very dangerous, but if it's borderline, you may get different opinions.
I see. Thanks. That's useful to know, I think, but obviously not. Doesn't yeah, be nice to have a bit of
Certainty.
yes.
Yes.
Just having a look at other questions that we've got. Someone's asked, can I claim for a heater not working in the bathroom for over a year after request for repairs? All of the heating in other rooms is working. So I suppose, yeah, that's presumably a heater that's provided by the landlord.
Yeah, absolutely. So that is a breach of the landlord's repairing obligations, because they have an absolute duty to repair certain types of things, including heaters, within a reasonable time. And a year certainly isn't a reasonable time. So whilst that wouldn't make your property unfit for human habitation because you have other heating, yeah, that is something that the landlord's in breach. Whether it would actually be worth bringing a claim in the county court for that alone is a different matter, but technically you could.
Thanks. We've on damp and condensation, coming up on here. How much time do the agent or landlord need to investigate the cause of the issues and find and yeah, how much time do they have and how much time does it take to investigate?
Yeah, I mean, it can sometimes be incredibly complicated to find out the cause of damp and, well, more leaks usually, that can be a mystery for absolutely ages. With condensation, it's less likely to be a mystery. It's more likely to be an obvious cause. But I mean, just completely practically speaking, it can be tricky. That said, probably the most they could reasonably say is a reasonable time is maybe 2 to 3 months. And during that time, they do need to be actively investigating. They can't just say they need time to investigate and not do anything. They do need to be sending people around. You'd expect to see people with damp meters, taking meter readings, potentially doing leak tests. If there was a leak, probably putting dye down to try and find where the leak went. But yeah, I mean, sometimes there are tricky cases when it does take time, but I would say anything over 3 months for damp and mold is getting out of the period of it being a reasonable time, and therefore it being a breach of their obligations.
Thanks, that's really helpful. We've got a question here. What if my landlord maybe signed a license agreement? Is there a way to fix this with the upcoming legislation without risking retaliations? I'm not sure if we can answer this specifically, but it made me wonder: are there any, in terms of a tenancy you might have as a for a home, and if you've got a license agreement, a license to occupy, what are the implications in terms of what your rights are there? And I know that sometimes license agreements can be shams as well. So yeah, if you were able to say anything on that, what tenants might be able to do.
Yeah. So yeah, so the first thing is it really a license or is it really a tenancy? And that's a complicated issue, but ways to tell are, do you have exclusive possession? That means, can your landlord simply, well, let's start from the beginning. If you share a property with you, if you live with your landlord in a house, like you're a lodger, then you definitely have a license. If your landlord can enter your property, or somebody on their behalf can enter your property without warning, then you have a license. So thinking something like a hotel, an Airbnb, a service department, a lodger agreement, any of those things, and you're definitely a licensee. If you are a licensee, then the only rights you have regarding repairs are what's written in the license agreement. So look to that agreement itself, and if it says the landlord has to repair things, then that's that. You have that obligation. You have no other legal protection, essentially, regarding repairs if you are genuinely a licensee.
Thanks. Do you may not have the answer to this, so I know it comes up sometimes, but if you're a lot of times the landlord will, particularly landlords who are the dodgier landlords, will give a tenant an agreement, say it's a license, in order to avoid obligations like that, even though the way that tenants occupying the home is actually makes it a tenancy. Is there anything, is that something you come across in your work? Is there anything that tenants can do, or in order to, is it a case of getting a court to rule that they're actually a tenant, or is there anything else that a tenant can do? Or,
well, I mean, usually it only matters in a situation where you need something like repairs to be done, or if your landlord's trying to evict you and you want to defend those possession proceedings, or for example, if they haven't protected your deposit, say, and then they're trying to evict you, and you can say it's not lawful, and that also that they should have been serving a different kind of notice. So if you have an unsure position but you have no problems, I'd say it doesn't particularly matter. And whilst you technically could go to court for a declaration that you have a tenancy and not a license, I'd say that would be absolutely not a worthwhile thing to do. You can issue a claim for disrepair on the basis that you're a tenant, even if it says you're a licensee, and then that will be one of the first things the court has to decide is, are you a tenant or a licensee? Or a far more common situation where it comes up is if the landlord either serves a notice to quit, which is what you'd use for a licensee usually, and not for a tenant, and then you defend those possession proceedings on the basis that actually you were a tenant and not a licensee, so they used the wrong kind of procedure. But yeah, it comes up fairly often, and I think it will come up a great deal more often when the Renters' Rights Act is enforced, because there'll be a lot more of an incentive for a landlord to have a licensee and not a tenant, so they can get rid of them more easily.
thanks. Yeah, it's definitely a concern. I know it's in some ways that the government is trying to tighten things up, but I think we're a bit worried about a few loopholes remaining. Someone has asked, what is classed as an emergency that would entitle the landlord to enter the rental property without any prior notice? So I think you've touched on this a little bit, but I know it's obviously that right to quiet enjoyment is obviously a big one, but yeah, what yeah, be
But
interested.
that's,
to get
yeah, just something really, really extreme. I would say probably the only things I can think of are a leak of a huge amount of water that was affecting another property below from one property, but not just a kind of normal leak or a damp patch. I'm talking, you know, a flood essentially, a fire, or I don't know, some kind of risk of structural collapse, but I can't really think of a scenario where that would happen. It's very, very rare that there's something serious enough where that's, I mean, think of a kind of scenario where the fire brigade might break into your house because it was just something very bad was happening and it was causing trouble downstairs or flat downstairs.
Thanks. Someone's asked if we can share the schedule or list of hazards we should look out for. We will we'll include a link when we're sending the slides around on that. Got another question here. I've received an improvement notice and got really confused with the penalties section. It mentions that they could face a £30,000 fine if the repairs are not carried to a specific standard. It also mentions about tenants where the council can go through first-tier tribunal for rent repayment order. What I found confusing is if on benefits like universal credit or PIP, who at the council would put in an application for RRO? Is that something someone can look into if you don't have the answer? I inquired with the council. No idea. Is that you? Yeah, is that something you come across that?
Whether the council will help you with a rent repayment order in this scenario when they're going to get the benefits?
Yeah, I suppose it's well, this is something that's come up for us actually, so I'm happy to give our view on it. I know that for a lot of people who are getting their rent covered entirely by universal credit or housing benefit, it's entirely up to the council to apply for a rent repayment order, and the council will end up actually getting the money and collecting that if it pays out. If part of your rent is paid for out of your wages, for example, and not out of universal credit, then the tenant can often put in an application for a rent repayment order. But I don't, as far as I know, it's not very common at the moment with councils to do this. But I know that there are some councils who are interested in this, particularly because so many of the dodgiest landlords are letting out homes to people who are relying on benefits. So it's sort of from a council's perspective, it's sort of trying to access more more in the way of fines from landlords. In a lot of cases, unless you're paying for some of the rent out of your other income, you would not be entitled to the rent repayment. But I know that it is possible to do a joint application with the council if you do pay some of your rent and the rest of it is covered by universal credit. So yeah, as I say, it's not especially common within councils, but I think the department that's most likely to deal with it are the environmental health team. Move on to the next one. So someone says, I thought F&G properties, so properties with an energy efficiency rating of F&G, were allowed to be let out if they have an exemption. That is correct. Yes, thanks for reminding me of that. There are a few reasons that a landlord can be exempt from doing that. One of them, the most common one, is the cost of the improvements. So if they would cost them more than £3,500 to bring a property up to band E, then they can be exempt from those regulations. As I think the last time anyone checked, there were only about 10,000 exempted properties, but about 200,000 properties that were F&G and rented out. So seems like a huge amount of non-compliance with this law. Obviously, a lot of councils aren't enforcing it, which is bad. We've got another one. Come up to. We've got 5 more. Let me see if I can rattle through them. What rights do you have if your property has not been cleaned, furniture is broken, and previous tenants' items have been left at the property? The agent is claiming the tenant had a party that caused all the mess, which is untrue. But I mean, I know I've experienced having moving into an unclean property before. Is there? I think it's very common for you to view one and it looks terrible, or and then it comes time to move in, as the letting agent still hasn't done anything. What are your rights in that situation?
You don't have a right to have a clean property to move into unless it explicitly says that in the tenancy agreement, which sometimes it does. Where this becomes relevant is at the end of the tenancy, if you move out, and then if the agent tries to say, oh, it's terribly dirty, so we're going to charge you for cleaning, when you can say, but it's in a better position than when I left it. So I would just document well and wait until the end and raise that if they try and blame you for something similar, which no doubt they will.
Yeah, thanks. That's really interesting. Yeah, it's worth remembering that the deposit protection system is another way, one of many different ways that we can deal with this. But it's obviously will take a while before you can actually exercise your rights on that when it's all about getting your money back at the end of the tenancy. By the way, we do have a session on deposits. That's on Wednesday. So if you're interested in hearing more on that, do sign up for that event. We've got next one. Mold has kept coming back in an ensuite bathroom with no window. It's taken 3 years to get a more powerful fan, but it still isn't enough, and it's coming back for this 5th time. So sounds quite specific. Any thoughts on that?
I mean, it might be unfit for human habitation. It's just hard to say. If it's a few dots, then if mold, then it's not. If it's, the whole wall's terribly moldy, then it might be. If it's quite a lot of mold and it's more than minor, then you might want to report it to the local council and environmental health department.
Thanks. So I've got a question here. I want to mention that I've complained to the property ombudsman about estate agents having a complaint, including damp, mold, and cracks, who have been acting on behalf of my landlord. I've no dealing with my landlord whatsoever. Will it be the property ombudsman, or do you think there might be a new ombudsman? Is it okay? It's okay if I've got no answer, but maybe something to look into. That's. I'll tell you what I know, which is that there are a couple of existing ombudsman. So the property ombudsman deals with letting agents, and what it doesn't really do is do anything relating to repairs, because it will tend to say this is up to the landlord, something that you can tackle through the courts or through the council. It's normally the property ombudsman will normally deal with complaints against letting agents where it involves problems with the contract, and the letting agent failing to meet either letting agent regulations or something to do with the contract that's been signed. There's a housing ombudsman as well that deals with the social housing sector, and that I think may also be in the running. It is in the running to run this new ombudsman, but I don't believe there's been a final decision made on that. So that's what we know at the moment. As I mentioned, it's not something that's going to be although the powers to create an ombudsman are going to be in the bill, which will hopefully be passed pretty soon. We won't have final details for a long while yet. We've got I'll read out these final three, and then we can wrap up. We've got a question. Maybe it's a rhetorical question. Is it fair that if a landlord has to do a number of repairs throughout the year, that they have a right to increase the rent to cover these costs or recoup costs towards them? I think this really should be part of the maintenance that a landlord has to do as part of getting rent, to be honest. In winter, the external wall does get mold that I remove with some mold remover spray. I normally do this once a month over the winter months. Should a property be totally mold free? And then finally, mold has been removed, but how long does a landlord have to make good plastering and painting to the original standard? Any thoughts on those two?
Yeah, so you shouldn't have to remove mold once a month, but that said, if it is a small amount of mold, then it may be that the property is not unfit for human habitation, whether you're going to be removing it once a month or not. Some people are. I mean, I've acted in a whole estate recently where all the properties were very, very prone to condensation and mold. It was in the Media, the Nag's Head estate. And we did find that some of our clients were absolutely religious cleaners and were cleaning every single day, and therefore their properties were not moldy. And other people's were not able to stay on top of it quite so much, and their homes were very, very moldy. And I would say that all of those homes are unfit for human habitation, because just you shouldn't have to be cleaning every single day and wiping down mold, etc., to stay on top of things. But all of these things are a bit of a question of fact, and usually I'd like to look at lots of pictures before I can say for sure. And then in answer to the question, mold has been removed, but how long does a landlord have for making good, plastering and painting? Again, they do have an obligation to do that, and they have a reasonable time to do that. What is a reasonable time? Probably a bit longer than they would have, because it's purely cosmetic. It might be, I don't know, a few months.
Thanks very much. That's the end of the questions. We managed to get through them all, I think. There's a couple of questions which we'll follow up with afterwards, which I've made a note of. I've just got a final slide to just let you know how to stay involved with what we're doing at Generation Rent. If you've got a story about your experience as a private renter, get in touch with our colleague Bisma, who is always on the lookout for stories from renters that we can share as part of our campaigning, whether that's sending information to MPs or telling stories in the media. As part of Renter Rights Awareness Week, we have a prize draw where we're giving away a number of books. A lot of books, kind of big books this year about housing, are on that list. We've got you're able to enter this link here at crowdfunder.co.uk/p/rentersrights 2025. That's open until next Monday. But yeah, it's a great opportunity to win a very good book. We've got a membership scheme. If you'd like to become a Generation Rent member and help support us and work we do, you can join for just £5 a month. And you can also, we're hopefully going to get a bill passed through Parliament very soon, but you can still sign up to the campaign at generationrent.org/campaigns/the-renters-rights-bill. That's all we've got time for. Thank you very much to Eleanor Solomon, our expert on all things repairs in the private rented sector. Thanks very much, and look forward to seeing you tomorrow if you're signed up for our event on the Renters' Rights Bill. But yeah, thank you very, very much for joining us this evening, and enjoy the rest of your evening.
Thanks. Bye.